Good morning. We're going to start in a few moments. Let a few more people sign in. Good afternoon, and thank you for joining us today. I would like to welcome you to the Fortney-Scott Briefing Task Force Guidance to Federal Contractors on the Vaccine Mandate. This webinar will be recorded. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's briefing will address the new federal contractor vaccine obligations outlined by the Safer Federal Workplace Task Force. Today's presenters are Fortney-Scott attorneys David Fortney and Nita Beecher. I will now turn the program over to David Fortney to start our briefing.
Valerie, thanks so much. Greetings, everyone. Nita, nice to see you.
Nice to see you, David.
Yeah, great to be here. And we have a lot of folks that are obviously interested in what is a really challenging set of obligations that federal contractors are now facing involving the vaccine mandates that President Biden announced on September 9th. So we're going to, that's a lot of ground we're going to cover, and we want to leave some room for some discussion and to address questions that some of you have. We've talked to a number of you over the last couple of days, and we know there's a lot of concerns, a lot of, as they say, devil in the detail about how we implement this. Let me just give a couple of preliminaries, and then we'll jump right into our topic today. About us, I think most of you know, we as a law firm, Fortney-Scott, we are a woman-owned law firm. We're very proud of that. We are based in Washington, D.C., and we do represent many employers, federal contractors, in dealings with the government enforcement agencies involving the workplace. Our attorneys, including both Nita and myself, have pretty significant experience in dealing with the agencies on a wide range of government contractor obligations. And I will say I know for certain, because I talk to Nita literally every day of the week, that she and I have both been deeply immersed in these most recent developments. Next slide, please, Valerie. Just a note, obviously, this is an informational session that, although we are discussing a number of significant legal developments, the purpose of today is not to provide legal advice. And I think all of you are sophisticated and understand that you should confer with your counsel, either your corporate counsel or your outside counsel as authorized, to understand how your particular facts may line up with these new obligations. So with that background, Nita, why don't you, let's just jump right into the agenda and get rolling.
All righty. We are going to just do a quick recap of what these vaccine mandates that have been rolling down are. But our real primary focus is to let everybody know what we know so far about the new federal contractor guidance from the Safer Federal Workforce Task Force, which from now on we're going to call the task force for obvious reasons.
You can tell a marketing person didn't make that name up, right? That's such a government name because it's unpronounceable and has no acronym. But okay, the task force, good enough.
The SFWTF? No, I don't think so. But anyway, then we're going to talk a little bit about, what we talked about the last time, but I think even more pointedly, we're going to talk about what employers should be doing. And then we really do want to leave about 10, 15 minutes for questions. And you can go ahead and put questions in the Q&A box, and we'll, if we can answer them as we go through, we will. But I think we're going to try and put them at the end for the most part, David.
Correct.
All right, okay. Next slide. So first, David, before we start talking about what the task force said, I know people are getting confused because there's so many different vaccine mandates. And for many federal contractors, they're going to have several overlapping mandates. First, obviously, and David's going to talk in more detail, the OSHA emergency temporary standards, which the ETS for employers with 100 or more employees to require vaccinations or weekly testing. The one we're really going to focus on today, which comes out of the executive order known as the Executive Order on Ensuring Adequate COVID Safety Protocols for Federal Contractors. It was going to require federal contractor employees to be vaccinated once they receive new contract clause. Federal employees are going to have to be vaccinated by November 22nd, with only those exceptions required by law, and by that they're talking about reasonable accommodation for disability or religion. And finally, one that we really haven't talked much about, but a lot of people have discovered they may be covered by it. It's from the Centers for Medicare and Medicaid Services. They are going to require vaccine mandates for workers in healthcare settings that receive Medicaid or Medicare reimbursements. And David, I think that's going to be a lot of people, nearly 20,000.
Basically, anyone that takes Medicare or Medicaid funding gets hooked with this vaccination obligation. So
David, could you just go over what we know about OSHA so far?
So, Nita, I kind of think of this as we have sort of layers of obligations, and the federal obligations are minimum obligations, but in order to kind of sort out, because they are somewhat overlapping, at least as a foundational point, I want to make sure that our federal contractors also recognize that the OSHA emergency temporary standard, which is not yet issued, but is coming, our best guess is that that will be out by the end of October. But let's talk just briefly about what the parameters of that will be based on what we know today. Number one, it's going to apply nationwide. It's going to apply to any employer that has 100 or more employees. Effectively, for our audience today, all of you are covered. It's not based on site or locality head count. It's simply if you have 100 or more employees, you're covered at all locations, number one. Number two, in terms of what has to be done, it's basically vaccination or a weekly negative test. Vaccination or a weekly test. Those are the options. It does not mandate a vaccine. It also prescribes that there are procedures that will be announced by the Labor Department in terms of providing paid time off to be vaccinated and to recover from side effects of vaccination. All that is to be on a paid basis. We know that you can use your existing PTO policy to address that, but you'll need to extend that to that. OSHA, this will be an OSHA standard, so there are civil money penalties for violations, potentially big ones, up to close to $14,000 per violation. That would be per employee per workday, typically. And many of you operate in states that have state OSHA plans. There's federal OSHA, but states, if they want to, can have their own health and safety plan. And for those states that have opted for that, there are 23 of them, they will impose their own ETS. They have to do so within 30 days after the federal OSHA imposes theirs. The states, we call them state plan states, those states can either simply adopt the federal plan, or they can adopt their own standard that's at least equally as effective, equally as protective of workers as the federal OSHA plan. So all of that is coming down. It's not yet issued. There is no advanced rulemaking. We don't know the great detail on it because an emergency temporary standard, excuse me, which OSHA is allowed to issue if there is a grave danger, that is the criteria under the statute, a grave danger in a workplace, OSHA can then, without the normal notice and comment, issue a standard. It will remain in place for up to 6 months. It then will be followed by a notice and comment period, and a permanent regulation would be put into place. But on the threshold, I think for purposes of today, we just want you to know it's ETS, it's not here yet, and that's not what we're going to be focusing on today. Nita.
I just want to mention two things because I think they're important when we get to the guidance. One, it appears that this ETS will not apply to remote workers. I think that's important to keep in mind. And two, we already expect there will be lots of litigation over this standard based on letters that have been sent by 24 attorneys general to the president and to the
To the
Department of
president.
Labor over there. So I think it's important to recognize that this is going to be litigated pretty quickly.
Right. And I just would add, many of you, we've had a number of clients who are based in the states in which the governors have committed they will challenge the OSHA standard. And we're having clients that are being contacted by the governor's office, the attorney's general offices are reaching out to determine whether the companies would like to join and support litigation to challenge the pending OSHA standard. Some companies are interested, some companies not so much so. But that's kind of the OSHA piece. Let's move into and talk really about kind of the new criteria that's animating federal contractors, because this is really kind of our new baseline. So the first foundational element, we've got this OSHA ETS coming, not yet there, and vaccine or testing. The new executive order, 14042, is the one that prescribes mandates for federal contractors. And that's what we really want to spend today honed in on. What does it require? It requires that anyone either working on a federal contract or in connection with a covered federal contract must be vaccinated. Must be vaccinated. So this is a much more rigorous set of requirements than the OSHA standard. OSHA allows you to basically what I would describe as test out. You don't have to be vaccinated. We don't have to deal with that. If you just want to be tested at least weekly, that's good enough. The federal contractors, that is not the case. It prescribes that you must be vaccinated. There is no testing option, generally speaking. It's very broad in terms of its coverage. This is going to be introduced into new contracts as they come online, and it covers a broad range of contracts that are spelled out there. Basically, the contract exception deals with contracts for products. But if you have a product, say you sell building materials, but you also include an ancillary service for the building material, that type of contract may be sufficient because of the service component to trigger coverage of these obligations. But generally speaking, most supply and service contracts, construction contracts, leasehold contracts, contracts involving concessions, and a wide range of services relating to federal lands, all are covered by these new obligations. In terms of new contract clauses, as new contracts are coming online, the executive order spells out a series of steps that are to be taken to amend the federal acquisition regulations. That's what is referred to as the FAR, F-A-R, Federal Acquisition Regulations. There also, for those of you that have defense contracts, is the Defense FAR, or DFAR as it's known. In this case, the FAR and the DFAR are going to be the same. They're going to match up and have the same requirement. There will be language published according to the timeline by October 8th as to what the new FAR provisions will be. Those FAR provisions then are to be added into new contracts that are being awarded on or after October 15. Many have said, well, that's good for us because we already have a contract and we're not looking to, our contract's good for 1 year. Be careful, because you need to understand that many of you hold indefinite quantity and quality contracts where basically you get services or you provide responses based on task orders or purchase orders. The underlying detail that we've seen so far makes clear that typically those new purchase orders will contain these new contract clauses. They're likely to. So there's this very narrow exception for products or very small contracts. Small for government contracts is $250,000. They view that as small. But for other contracts, generally speaking, whether they're entering into a brand new contract, a brand new extension or modification, or even through the purchase order process that goes forward after October 15th, these new provisions are supposed to be included. Let me pause there. Nita, anything else on those? That's kind of a foundational what the EO
Yeah.
has in that contracting.
Well, the weird thing, David, about the executive order is it didn't tell contractors what they were going to have to do, as opposed to the executive order for federal workers that said you must be mandated and you must be mandated by November 22nd. What they said was the task force would issue guidance on September 27th, so 24th. And so sorry about that, September 24th, and they did. So let's go to the next slide and see what that guidance actually says. And I think it's important, David, we'll talk a little bit later. This is guidance. It's not a regulation. It's not gone through, and they don't have, the emergency temporary standard type of a thing for this. But here it is. Who has to be vaccinated? First and foremost, vaccination only, just like federal workers. There's no testing is an option according to the guidance as it comes out. So it's going to be all full-time and part-time federal contractor employees. Now, it's employees, not workers, who work on or in connection with a federal contract must be fully vaccinated. And in this case, they've made it very clear it includes remote workers if they fall in the definition. So those employees who are in connection with, David, this was the part that we wondered about. When we talked about this a couple of weeks ago, we said, well, if you look at paid sick leave or minimum wage, it's usually people who spend 20% or more of their time on federal contracts. That is not what they did. They are saying a very broad definition of employees in connection with, and that would be those who perform duties necessary to the performance of the contract, but who do not directly engage in performing specific work called for by covered contracts, i.e., we're talking about human resources, billing, and the law. They say law review, but I think they just mean the lawyers in the law department. So, David, when I read this, it says everybody in corporate office probably is going to be covered.
Right. And I
now,
think
I'm sorry, go ahead, David.
Go ahead, Nita. Go ahead. I'm sorry.
I was just going to conclude, and then, David, I want you to hear what you think about this. The only exception to this is a reasonable accommodation for disability or religion. And we'll talk, David, I think we do need to talk a little bit about that later on, because this is going to be, this whole reasonable accommodation for religion is turning into like a giant problem.
Right. Well, so let's put a pin in the accommodation point and come back to that. I want to make sure that we start with who has to be vaccinated. So anyone working on the contract, okay, that's a given. The in connection with, as Nita explained, the 20% is out the window. So it's pretty much anyone I'll say corporate services. Think about your headquarter function. Now, many of your organizations, of course, hold multiple contracts. You may do both commercial and government work, and your government work portfolio may consist of multiple contracts. So I think the practical challenge, as you really bear down on this, is that as soon as one of those government contracts is amended to include the new obligation, unless you can somehow wall off your corporate services, your headquarter function, it will trigger immediate, it will trigger obligations for the corporate function as well as those that are involved in the performance of that contract. Many organizations, the government work is often intertwined with the commercial work, and so it's very hard to segregate. And the standards for segregating who does government work, because if you have any cross effort or even exposure to people doing government work, then everyone at that site has to be vaccinated. Nita.
We do have a question, David, which I think is important to answer at this. If the contract, and I think we need to be a little bit careful, if the contract is less than $250,000, will it be covered?
Yeah.
So go ahead.
Yeah, we can answer that. It is outside the scope, but the president has said to his contracting officials, and there are 50,000 government contracting officers around the country in all the different agencies. He's told every one of those contracting officials, for those contracts that are outside the scope, say a contract for $200,000, it's below the threshold, you still are strongly encouraged, that's what the president said, strongly encouraged to go out and ask for a voluntary modification and agreement to include these provisions. And I will tell you this morning, before joining this webinar, I actually conferred with a client that has gotten not one, not two, 5 separate requests for voluntary modifications this week. Yes, the clause isn't even out, and they've got contracting officials coming out of the woodwork saying, this is a priority for our agency. Will you agree to these vaccine mandates? So that's the way it would work. And as a practical matter, you as the other party to the contract, you could decline to enter into that modification for the convenience of the government. And I think you're a sophisticated contractor, you'll know the government will take that into account and may look to other sources that are more willing to comply.
Correct.
So it doesn't get imposed by operation of law, but it gets imposed by, they're going to say, pretty please, will you agree? And you'll make a business decision whether you will or won't.
And we'll talk, David. I want to get through this section, but I thought that was an important one.
Right.
Let's talk about when these contract provisions are legally going to be imposed. And Valerie, if you'll go to the next slide.
Right. So we sort of touched on this, and this, I think, is just to help pull this together for folks. When options are exercised or new contracts are awarded or extensions made on and after October 15th, that becomes the date. So notwithstanding that we have some, I'll call them eager beaver contracting officers that aren't waiting till October 15th, this program in theory isn't supposed to start until then. And when we say contracts, that also, as I've indicated, includes purchase orders and a wide range of other efforts. For new contracts that are going to be awarded on and after the October date, they will be, the award will be effective in the solicitations beginning on the 15th. Those contracts may be awarded beginning as early as November 14th. So October 15th, the clauses become available. These are new contracts that are being put out for proposals and responses, bids. They're being awarded. The awards may be made as early as November 14 under that process, and the clauses will be included there. Once the clauses come in, then the obligation is now, because this flows as a matter of contract, this is a difference between that OSHA regulation, which by operation of the OSHA Act applies to all employers with 100 or more employees. The contractual obligations only apply as they are added to your contracts. And for those employees that are performing or providing services related to the performance of the covered contracts. So figuring out when the contracts have a new clause added, a new clause has to be added. This is not self-executing, and the new clause will be added either through the bid process, through the procurement, purchase order, drawing down services process, or through voluntary modifications that the contracting officers will be seeking. Anita.
One thing I wanted to point out, which we didn't talk about on the previous slide, is in the task force guidance, it says that contractor employees who are covered must be vaccinated by December the 8th. Now, that's a little tricky because they really have to have these clauses in order to actually implement that from a legal perspective. But I think the way to look at this is that by the time, according to the guidance, by the time you get this clause, everybody who's going to work on that contract must be vaccinated.
Right.
And everybody who's in connection with, and we have a question here, David, that I think is interesting. Here is a question of if you hire a general attorney that works on various projects, including federal contracts, does that person have to be vaccinated?
I would say yes. Assuming that you have one or more contracts that now contains these new provisions, these new obligations, that the attorney that you've described in the law department would be deemed to be providing services in connection with the performance of the federal contract. So the answer would be yes.
And
Nita,
I think the next thing, I'm sorry, go ahead.
I'm sorry, I want to make clear on this December 8th, because new contracts will be coming online, and yet the government has recognized it takes, I like to use 6 weeks as a yardstick to get people fully vaccinated if they go through a 2 vaccines regime. Some lead time, getting the first shot, waiting a couple weeks, second shot, waiting a couple weeks till you're fully vaccinated. So 6 weeks, we'll just say generously. What that means is that as these new contract obligations are coming on, the government has recognized that you need some lead time, and that's why the president keeps saying, get people vaccinated now so you're ready. Right. The government is going to hold you accountable for those employees performing service on and after December 8th. That is the, I'll call it the so-called drop dead date for when the vaccines need to be complete. But of course, if you wait until December 8th, those people aren't going to be eligible to perform work at that point. So that's the point. That's what, there's the contracting process. Your contracts will be in place. They are supposed to recognize some lead time, but by December 8th, that is the deadline that is prescribed for all service provided on or after. Those that are covered, working on or in connection with, will have to be fully vaccinated. Fully vaccinated. All right.
David, we have a couple of questions around the next bullet. So you want to talk a little bit about the flow down provision?
Sure. I think most are familiar, maybe because of Executive Order 11246 and some of the EEO obligations, that generally speaking, when you have contracts, when you enter into subcontracts that are necessary for the performance of your contract, that you have to include certain provisions, certain obligations, and that the subcontractors will agree to those. In this instance, this will become yet another flow down obligation. It will go on what is a rather long list of terms you are supposed to include and flow down, and you will require your subcontractors and that in turn they will require any subcontractors they use. So there is no cutoff. This goes to subcontractors at any tier of the contracting relationship. Each tier above is to flow down, impose the obligation to the next tier, and that continues repeating. So those obligations will go in, and they will be the same clause that you were required to sign in your contract. Does that cover that, Nita?
That's right. Yeah, I think so. And I think what's really important about this is that the guidance provides, David, that it is not the obligation of the prime to make sure that the subcontractors get vaccinated, only that they flow it down.
Right. That is correct. So we're not our brother's keeper, if you will, in that sense. Our obligation, these are contractual obligations. So just keep that in mind. We are responsible for our own employees, those that work on or in connection with. We're responsible to the extent we'll get to what you do for visitors, and we're responsible that any subcontractors, we put the clause in so they in turn can be responsible for their employees who work on or in connection with.
So the question is, David, let's go to the next slide. What is it that the federal contractors have to do? So first of all, we've been talking about when, according to the guidance, they must be fully vaccinated on the first day of performance on a contract that has the clause in it, as David was mentioning, on or after December the 8th. But again, remember, you have that approximately 6-week lead time to get those people ready to go. So you need to be thinking about, are they vaccinated? Are you ready to go on those provisions that might be rolling out at any time in the near future? The other thing that I think is important to point out, David, is that contractors are not required to keep documentation of vaccine information. They have to look at proof of vaccine for each of their employees, but they don't have to keep it. And I'll talk in just a minute about what those are. But unlike the prior guidance in July, attestation by an employee that they're vaccinated is not enough. An antibody test is not proof of vaccination. Employees that had COVID-19 must be vaccinated. And we talked before about the EEOC requirements that when you collect this data and you say, check, Johnny's been vaccinated, Susie's been vaccinated, and whatever, that information needs to be kept as a medical record like any other medical record under the ADA. And David, just to give a really quick overview, as I recall, all of the things, it's things like the form that we got when you're vaccinated. It's a documentation from your doctor that shows that you were actually vaccinated on day X. Documentation from CVS, Walgreens, Walmart, wherever you got it. Those are all, and it's all spelled out in the guidance, what are those things which are covered and can be done. Now, here's another important point. While you, the federal contractor, have to collect data on your employees, you do not have to collect data, vaccination data, from visitors or subcontractors. Obviously, the subcontractors will have to collect their own data. Let me just see if we have any more. We have so many questions, guys. I'm going to hold these to the end so we can get through it.
That this, one or two other points. So the vaccination,
sure.
You don't have to retain a copy of the vaccination record, but you do have to inspect. I think this is kind of like the I-9 process. You have to actually sort of look at the documentation.
Exactly.
I think that's a good analogy that many of you may think about. You know, you have to look at the documents. The government doesn't prescribe that you keep them. Many of us do keep copies to demonstrate what we looked at and the good faith compliance, but you're not obligated. Nita mentioned if you do opt to keep a copy of what you examine, that you have, of course, the medical record. The other thing I'd like to add, going back to OSHA, if you keep a copy, that would be an OSHA record, and OSHA has a very long record retention obligation of the duration of employment plus 30 years, plus 30 years. So one of the work sessions I was in was with a client, and we were looking through their Workday HRIS to kind of create a tab that this type of documentation would be kept in, totally walled off specifically. And of course, it's going to be tucked away up on the cloud for 30 years, employment plus 30. So it's a very significant obligation. That's causing some people to say, you know what, I'm going to have a standard protocol. May not keep records, but I'm going to be very strict on what I look at. And you can also look at a photograph of someone's vaccination card. Nita.
That's right. But it's important to remember that the fact that you're going to have a check mark next to their name that they've been vaccinated is still considered to be a medical record. So if you put it on the cloud in a protected area, that's going to work fine, even if you don't keep copies, but just have to keep that in mind. Okay, so David, let's talk about the safety protocols, because in addition to everything else, the task force provided safety protocols for all federal contractors.
Right. So there are some safety protocols, and these are prescribed. I think that these are manageable, and there's sort of a good news, bad news part of this. The good news, as we said earlier, is that other than your own employees, you don't have to check vaccination status of others, but you are responsible, particularly if you're running a site, that all visitors at the facility are maintaining the proper protocols, masking, social distancing, and other guidances may be changed in the future by CDC. There are some very, very limited exceptions. They deal with offices with a door on them. Presumably it means with the door closed, but they don't actually say that. Or if you're actively eating, this is something they're trying to drill down on the, you know, people ever goes to a restaurant and they kind of take the mask off for 2-3 hours while they're there. No, they envision when you're eating, you may remove the mask, but otherwise the mask is back on, which is not what I've observed people doing. So the contractor at your facilities, you will be, I'll call it the mask police. You will be responsible for enforcing these types of the social distancing and masking obligations. Additionally, you'll need to have appropriate signage explaining the safety protocols. I think most of you do at your facilities now, but you'd want to make sure that those are fully up to date. Finally, And one or more individuals will need to be designated as a coordinator of this. Again, most people are finding that within this doesn't require you to hire a new or create a new FTE. This is assigning under other duties as assigned, whether it's your health and safety, your compliance, sometimes it's HR, but there's a variety of functions, sometimes a site manager. Someone, the point is to be responsible for coordinating these efforts at your covered workplaces. So those are the requirements there. This puts, I think, some real burdens though on contractors, not just getting your own employees vaccinated. It's not you're done with that. You still have these other obligations for which you'll be held accountable.
And David, before we kind of close this part of the conversation out, let's talk about what other things the task force brought up on the next slide. And I think this is going to be really controversial, I believe. The guidance says that it overrides any contrary state and local laws and ordinance which are less stringent. So that means, I think it's Montana and Texas and North Dakota, which say you cannot mandate vaccines. I believe those are the states that do that. The guidance says that it overrides state and local laws. Do we believe that, in fact, is correct, David?
There is some case law on how OSHA goes about preempting state laws. And way before this current dust up, the Supreme Court had said, that the provision in OSHA that addresses that is rather narrow. It really is meant to preempt, to set aside state laws that attempt to directly regulate workplace safety and health. So the question that will be sorted out is, for these broad-based state laws, Montana, you cannot, the anti-vaccine passport law is how I would describe it. You can't ask someone whether they're vaccinated. Well, of course, you can't comply as a federal contractor with these obligations without asking. You're under contractual obligation to ask, and yet you may have a state law that says you're not permitted to ask. How's that going to be resolved? Is that in fact a law dealing with workplace health and safety, or is it broader to deal with admission to a business, admission to school, a whole variety of things? That will be sorted out by the courts. Note, however, that state laws that are even more rigorous than the federal contracting requirements, you are not excused from complying with those laws. You also must comply. You must comply with the federal contractor obligation plus any more demanding obligations. So for example, just because you're a federal contractor, you would not be exempted from complying with the OSHA record keeping requirement that we mentioned a moment ago. Okay.
Well, and David, that takes us right to the ETS. So it's possible that the OSHA ETS may have additional requirements over and above what's in this guidance, and you're not going to be exempted from that. That is going to be basically overlaid on your obligations already, right?
Right. So I kind of view this is what I call the Grand Canyon analogy. We've all seen that beautiful layers. We start with OSHA, then we have contractor obligations, and in some states or localities, New York City and other major metropolitan areas, California, there are yet additional obligations. As a federal contractor, you fully have to comply with that federal contractor layer, but to the extent that the other layers provide more protective provisions or obligations, you also will be required to comply with those as they may apply to you. But the federal contractor
and I think, And David, I do think the funniest thing of all this is that they're throwing into the laps of the federal contractors what accommodations are reasonable. So it raises some interesting questions. In July, there was an ability to test rather than be vaccinated, and to test and then require vaccination, require masks and social distancing. And is that going to be a reasonable accommodation? Working from home, although it says remote workers are required to be vaccinated, will individuals be allowed to be accommodated by working from home? This is different, I believe, from the OSHA ETS, which allows testing as a reasonable accommodation. We don't know, and we know that especially the religious accommodation is being pushed very hard in some areas to object to the vaccines.
Correct. And this is one area that I think is particularly challenging, and it's become more difficult because so far to date, the government, the procurement arm of the government just has not been forthcoming. It basically has said, contractors, it's on you. You have to figure it out. You have to comply with the EEOC guidance and so forth, which is fine. I don't think anyone objects to that. We're good on that. But the challenge is that some of the heretofore accepted accommodation practices, as outlined by NETA,
Right.
would appear to be prohibited by the government contracting obligations. This is one where, at this stage, we have more question marks than we have answers. And we have submitted formally to the Department of Defense a request that they provide greater detail and guidance as to how we can do this, because everyone wants to comply with their contractual obligations, but we also, of course, have to comply with Title VII, ADA, etc. So this is, I think the short answer is, the realistic answer, we just don't know fully what something's going to have to yield. And I think it's going to have to be the absolute rule saying testing is never permitted. I think they're going to have to recognize that, at least in some circumstances, even though they are concerned it will become a loophole for the vaccine mandate, that many people will particularly likely focus on religion, that it may result in, I just think they're going to have to recognize that accommodation, but we don't have that today.
So David, let's look at our little list here, one more slide, because I know we have a ton of questions. Oh, back one. Ton of questions we want to get to, and I know people have got, I can see the blinking light is telling me we've got a ton of questions. So anyway.
Got it. Okay, so
David, why don't you kick this off?
Sure. I think a lot of folks are finding, I mean, this is all over the news, don't get behind the curve. I think you should be talking to, even if you don't have all the answers, you need to start a communication and develop a communication strategy. You want to become the source of factual information for your workforce. You don't want them going off filing charges or claims or complaints or being concerned. I think you need to be forthright, and you need to start a process whereby you're informing them of the new obligations that may be coming online. You're informing them of commitments and committing that you will be keeping them informed as the protocols are developed and rolled out. You might develop some Q&A on those that say, I'm never going to get vaccinated. I'll quit before I get vaccinated, because depending on where you are, what part of the country, what industry, that could be 2%, it could be up to 10%. There will be, it seems, across the board in almost any occupation, we're seeing a group of hardcore, I will never be vaccinated. And you will need to develop comms to address that too. Nita.
I think the next thing, David, is you really have got to start thinking, unlike the OSHA ETS, which is going to give guidance on, or so they say, on vaccination and testing protocols, I think you need to start looking at what is going to impact you in your workforce that's going to have to be vaccinated at some point. Find out how many people are already vaccinated. Why don't you go ahead and start that and start checking off so that you know what that group of people that you need who are not vaccinated, who are those people, and figure out what state and local laws you might have to deal with. And I think also, like David was talking about, start thinking about how you're going to keep that vaccination data, whether are you going to try and take a copy of their cards, or what is it you're going to do, and then how you're going to keep it.
On the accommodation, I think we've pretty well addressed that. Even though we don't know ultimately what's going to be allowed, at this point, you should have a pretty well developed, I'll call it tool chest, ways in which accommodations can be handled. I would be ready to be nimble on that. For example, if you're going to deal with ADA accommodations, are you going to require a doctor's note? Are you going to do one note? Are you going to go to the 3-doctor option? How detailed are you going to be? Who's going to collect the information? How's it going to be held? I mean, there's a wide you know, are you going to decide, are you going to challenge if people say they have a religious belief? Are you going to challenge whether it is a bona fide religious belief, as some organizations are doing? Or instead, are you simply going to say, let's focus on whether we can accommodate, we'll assume for a moment that your religious belief is bona fide. Let's talk about how we can accommodate it. Those are all strategy decisions. And in my view, those can largely be sorted out now, right now, in making the decisions.
And then
Peter?
finally, before we jump to the dates, really is, if you have collective bargaining agreements, primarily you're going to be looking at effects bargaining. You need to determine whether that's going to be, any bargaining will be necessary, because these are going to start rolling out, as David said, fairly quickly.
Right. Okay. So just quickly, let's end up, and then we'll spend the rest of our time together on your questions. These are just some key dates that we're watching that I think are helpful to keep in mind. There could be unscheduled developments, obviously, as there tend to be. Those, for whatever reason, always seem to be on Friday afternoon. So I kind of always look starting 3 o'clock Eastern to see what they're up to. But the FAR Council is to issue policy directions to the acquisition officers on these new contracting procedures. That's going to be important because that's going to give us a preview of what the language and what the mechanics are of changing the contracts, October 8. 1 week later, that's that new contract clause that I talked about under the FAR. And so for contracts awarded on and after October 15th, that new clause is going to be put in. We also believe that the OSHA Emergency Temporary Standard, ETS, will be issued sometime in October. We think the second half of October. And we say that because the Solicitor of Labor told us a week or two ago in a quick briefing that it would not be days, it would not be months. All she would say is it would be weeks, which is like playing 20 questions with your 6-year-old. We think that means the end of October. But to be honest with you, the last time OSHA took many, many months to issue the ETS that's in place for the healthcare industry. So we don't know, that's a guess. November 14th, that's the date by which the new FAR clause that we talked about a moment ago is to be incorporated in all new contracts that are being issued. And December 8th, big date, that means that to any of your contracts that now contain these new obligations, that is the date by which employees performing on or in connection with will need to be fully vaccinated. Okay, Nita, I think that serves as a good recap too on kind of the key points. What do we have in the question box? Do you want to run some of those?
We have so many. All right. So we answered the 25,000. Let me go. So the task force and the EO say it does not apply overseas, but if you're a federal contractor with workers throughout the United States and various locations in different companies, do you segment your employees, or do you keep all the employees included in the mandate?
It's kind of up to you. The government guidance issued so far does recognize that if you can really wall off workers so that they don't have, your employees so they don't have any contact with those who are performing directly or in connection with, doing work directly or in connection with the government contract, that they could fall outside the vaccination obligation. But the requirements on keeping that very pure, are very demanding, and many clients that we've been talking to have found that initially attractive, and then they've tried to figure out how to operationalize it, and it kind of got bollocksed up. So it's possible you could segregate and keep, like, put a concrete silo and not have them interact. But that may be not practical. But that's an option that is recognized in the guidance.
We kind of answered this, but I want to make sure we cover it. Here's a question. Is a subcontractor only obligated once they receive a contract amendment extension with a relevant FAR clause? Is the onus on the prime higher tier subs to include that? I think the answer is yes, I believe. Correct.
Yeah, that's a good reminder, though. These aren't just self-executing. These are dependent on contract, and you know the rhythm of your contracts. You know when you're getting purchase orders or modifications, or if you're bidding on new contracts. So basically, your procurement representatives need to be on the lookout they're kind of the first line of defense to identify when these clauses are coming into the system, being proposed, and to help everyone be informed on when your company may be obligated if they're agreed to.
And I think, David, what you said earlier is expect them sooner rather than later. At least a lot of people, a lot of the contracting officers are jumping out to start asking people to do that.
Right.
Similar question, but I think it's good to respond to this. Should you wait until you have a contract that's covered, or lean forward if you know you will be impacted at some point after those dates? So should you go ahead and get people vaccinated?
Yeah, I think the answer is yes. I think most are leaning forward, to be honest. I think that's the vast majority of folks we talk to. And that goes back to that communication strategy. They're explaining to the workforce, they're starting soft. They're just surveying, just tell us, are you vaccinated today? Yes or no?
Right.
You know, we have some obligations that may be coming down. We're trying to get a sense, how many of our people are vaccinated? You know, we got 80% vaccinated. Okay, great. So now we know the 20% we need to focus on where they are and how to deal with that. And you begin to get developed like that. But I think most people are working it in advance.
Yeah, I think that's right. Well, the 6 weeks is really a big deal. You know, you can't just decide to start getting people vaccinated the day you get the contract, because they're, you know, they're not. It takes a while to get to that point. Going back to what contracts are covered, there is mention of procurement in the executive order, but the guidance seems to be far broader and includes more than just procurement contracts agreements. Should we be following the guidance, or does the language in the executive order supersede? And the one thing I'll say is that both the executive order and the language in the task force guidance talks about contracts and contract-like instruments as defined in the minimum wage proposed regs from June of this year, David. So I think they're aligned, but it is very broad. It's much broader than usual for federal contractor obligations. But go ahead, and what do you think?
And let me just point out specifically Section 2B of the executive order refers to the guidance. And in that, it says that the guidance, basically it says guidance is going to provide all the relevant terms and definitions that are going to be followed. So even to the extent the executive order is being read as being not quite as fulsome, not quite as broad, the executive order anticipated that they wouldn't be able to flesh out all the detail, and the executive order in advance has effectively incorporated by reference the subsequently issued guidance, and it is I would deem it to be binding and follow it.
Right. All right, so if the prime or the sub doesn't incorporate or flow down the new clause, is the next tier sub not obligated because they're not on notice?
The flow down is an obligation of the superior party. So if you're a subcontractor and it was not flowed down to you, you do not at that point have a contractual obligation. Be prepared that if the government finds out, they may seek to have it further modified and to correct that oversight. They may hold the prime contractor accountable for that. Maybe you could hold the prime contractor accountable for an adjustment, but these are contractual obligations. So unless and until it is included in one of your contracts, you are not covered.
Here's a humdinger that we've been talking about among ourselves. How does this apply where the federal contractor status is based on FDIC coverage, David?
Yeah, we've been trying to unravel that a little bit ourselves. In other programs, let's think about Executive Order 11246 for non-discrimination and affirmative action. Basically, in that program, the Labor Department has deemed that the FDIC insurance program constitutes a covered contract. We don't yet have that type of guidance, though I will say I think it's imminent because the clear intent is that every possible contract vehicle, except for those very narrow exceptions, are intended to be covered. I have not fully parsed the FDIC, whether it's a contract-like instrument. There's some very broad language that is very encompassing of that. But so the short answer is we have not specifically worked all the way through that. I think the more likely result is going to be coverage for FDIC.
Right. Okay, we have some employees on the commercial side who never cross paths with federal employees in our offices or work sites. Assume they are not covered? Ooh, there's a good Q&A on this one, David.
There's a good Q&A, and I think because you've got sort of two groups of employees. Now let's talk about production employees. Let's take a hypothetical. Let's assume that you have a retail grocery store and you have a retail food distribution business and the retail warehousing and distribution. The warehousing and distribution folks service the government, but the retail has no government contractor presence. I think you might be able to, for example, wall off those retail employees because they're not necessary, they're not performing in connection with the contract. And so that's kind of the production employees. You have a separate facility, they only do commercial, they don't do anything relating to it. They're a discrete unit or division or component of the company. You have a pretty good argument that that site is outside of coverage. But your corporate services people, unless they are similarly walled off, and most organizations today that does not exist, they pretty well get blurred together because of the efficiencies. I think it's likely your corporate services staff in their entirety would be covered based on the guidance we've received.
Yeah, there's Q&A that really talks to this and basically says they can't cross paths in any common spaces, parking lots. I mean, it's really, so you should look at that very carefully because it's going to be tricky. I think we've answered that we think OSHA rule will be published in October. Question of mid versus late October. They've been kind of slow. So what do you think?
Yeah, I'd have to say second half of October. So I'd go that far and guess, but and you know what? That would be lightning speed compared to what they've done
Correct.
in working on the ETS up to date. They took months, even when they were previously, they were told by the president, get your ETS done by March 15, and they were about 3 months late on that.
June.
So who knows?
Yeah.
We'll see.
So on our legal challenges questions, there's really I've got two questions here. One, will there be a legal challenge to the federal contractor obligation? Will that be successful? And then also to the OSHA ETS. And the real question is, how do you think these how will they fare in front of the courts?
Sure. Yes to both. There will be, I think, legal challenges to both the contractor and the OSHA standards. The governors at a minimum, and I think there are other trade associations, the Retail Federation and others have indicated that they are going to seek to file judicial challenges to the OSHA ETS. On that one, I think that those that are challenging have a better than even chance of prevailing. It's very hard for OSHA to meet the standard of a grave danger in every single workplace, which is what they propose doing. Number two, it's hard to demonstrate that the Delta variant is in fact workplace related and not due to outside work activities.
Right.
Three, they have adopted a standard of 100 or more employees. It's hard to understand how a company with 95 employees is at less risk than one with 105 employees. That potentially could be challenged as being arbitrary. So I think the OSHA standard is potentially in greater risk. I would note earlier this year, the administration looked at issuing a nationwide OSHA standard and they wouldn't do it because they felt it might be successfully challenged, and they issued it only for the healthcare sector.
So David, do we want to spend about 5 more minutes answering questions? I still have a ton of questions here.
I think
sure, I'm sorry.
The challenge to contracting standard, yes, there will be a challenge. I think the government on that one has a much greater likelihood of success. The government has a lot more latitude in imposing terms like this as a matter of contract, and you have less grounds to challenge because it's prospective, and the answer is, look, if you don't want to comply, don't work on the contracts. These are all new contracts, don't agree. You don't have to do government work, you can do commercial work. And those types of arguments often carry the day in defending these types of obligations for contractors.
Okay.
Okay, Nita, sorry.
No, I was just going to say, it's now the top of the hour. I've got more questions. Do we want to answer
Pick
a few more?
Let's do one
Sure.
more.
Okay. All right. I think this one is the one we ought to.
Okay.
If an employer grants a religious, or it should be disability, reasonable accommodation, then what? The individual goes on working as normal. And what if accommodation request includes not wearing a mask?
Well, remember, it isn't a question of what they ask for as an accommodation. It's a question of what you will agree or permit or authorize. It is hard to imagine that an individual who claims that they cannot wear a mask, that there's any way to accommodate them unless they can be fully remote and never have any interaction with your workforce. But you know, so I think that, remember, you're the arbiter of what is going to be an accepted accommodation. They can ask for the star and the moons, but you will decide, and hopefully we'll have a little further guidance as to what the government will also be willing to recognize. One of my concerns is that the government's going to say, look, you can accommodate these people. They're not going to be allowed on site. And to the extent that they are essential employees whose contract require them to be on site, they may not, the individual may not be able to meet the basic qualifications of the position. Comparable to some jobs require security clearances. If you don't have a security clearance, you can't come on site and you can't do the work.
Correct.
And most people at that point face a layoff or an unpaid leave of absence, or unless they can find some other assignment, which you're not obligated to provide.
Okay. There are more questions. We will try to put together some FAQs out of this, David, that we can put on the website for folks.
That would be great. Good. Well, Nita, thank you. We've covered a lot of ground, and as the questions demonstrate, none of us have all the answers. So we're going to keep working on that and see what we can do. But we appreciate everyone joining us today. And Nita, I appreciate co-presenting with you.
Thank you, David.
Thanks, everyone. Be safe.
We would like to thank everyone for joining us today. You will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through this survey. Thank you in advance for completing the survey. And of course, if you would like a copy of the slides, please email info@fortneyscott.com. Also, please subscribe and listen to our new DC Insider Employer Update podcast, which you can find on fortneyscott.com or anywhere you listen to podcasts.
Super. Thanks, Valerie. Bye, guys.